I'm driving on a perfectly normal day when, boom, I see a blinding light. Think God just took the wheel, hit the gas, cross the center line, and slam into another car. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Am I legally on the hook for negligence, or do I get a pass because my mind just snapped? That's the wild opening to Breunig versus American Family Insurance Company, a 1970 Wisconsin case that sounds like a meme, but set a real rule. Here's the story. Mrs. Breunig, a woman behind the wheel, suddenly believed a higher power was steering for her. She thought the car could fly like superhero-level delusion. She accelerated into oncoming traffic and crashed into Mr. Veith's truck. The insurer, American Family, got dragged into court. The big question, is a sudden mental breakdown the same as a sudden heart attack or seizure, something that can excuse you from negligence? Here's the rule. A sudden mental incapacity can be a defense to negligence, but only if it hits like lightning with zero warning. If you had any reason to see it coming, you don't get the excuse. Why that matters: driving is a constant duty to control risk. If your mind goes offline out of nowhere, the law can treat it like a sudden physical blackout. But if you've had prior episodes, bizarre warnings, or clues that something's off, you're expected not to drive, or you and your insurer eat the liability. Back to the case. Evidence showed the driver had weird, earlier symptoms, visions, talk of forces taking over, stuff that made this more foreseeable freakout than bolt from the blue. The court said, the defense exists in theory, but not here. The jury could find her negligent, and the insurer had to pay. Let me make this super clear. Sudden, unforeseeable mental snap while driving, possible defense. Any warning signs, prior delusions, treatment clues, erratic behavior? No defense. You're liable. This isn't a free pass for insanity behind the wheel. It's a razor-thin lane for truly unpredictable mental collapse. The court drew a line so people can't dodge responsibility with vague claims, but someone hit by a real, no-warning mental blackout isn't automatically branded negligent either. So, what do you do with this? If you, or someone you love, has had recent episodes that mess with judgment or perception, don't drive. Judges and juries will look for any hint that you should have known. Foreseeability is everything, and for everyone else, this case is the blueprint for how courts balance compassion and accountability. Now you know, God took the wheel won't save you. In court, Breunig versus American Family Insurance Company, 1970. Thank you for watching. If you enjoyed this case, please follow along for more. See you on the next case.